The first and governing maxim in the interpretation of a statute is to discover the meaning of those who made it. Hello, I'm Alan Scholl for the Freedom Project, sponsored by American Opinion Foundation. In this episode of our Principles of the Constitution series, we're going to concentrate on judicial powers and limitations. The judicial branch is also known as the Supreme Court. This quote by James Wilson is particularly important to the judicial branch. James Wilson is one of 6 unique men who signed both the Declaration of Independence and the Constitution of the United States. He was also the first Supreme Court justice appointed by George Washington. Here's a question for you. True or false? No ruling by the Supreme Court can be overturned by another court. The answer is true. The Supreme Court is the highest level of appeal in the United States court system. The founders designed the judicial branch with just a short list of very specific duties and responsibilities. To review cases and laws in light of the Constitution, to judge cases not solved by lower courts, to judge cases not in a state's jurisdiction, to judge cases involving non-U.S. citizens, to ensure that all courts operate under guidelines of the U.S. Constitution. Of all the 3 branches of government, the judicial branch has the least amount of political power. In fact, the entire creation of the Supreme Court takes up less than 375 words in the Constitution itself. When the Constitution was written, there were 2 radical differences which separated our judicial branch from the judicial branches of all other countries of the time. The first is a trial by a jury of peers. In other words, a judge cannot determine if the person being tried is guilty or innocent. That responsibility is voted on by the jury. The second is that in many countries, judges are able to make laws. However, the Constitution clearly states that lawmaking is the responsibility of Congress and not the courts. To emphasize this point, we'd like to bring in our friend Dr. Smith, who is considered an expert in American politics and constitutional law. Dr. Smith, is judicial lawmaking constitutional?
Judicial lawmaking means that the court is engaging in a process that's more properly reserved to Congress. Almost by definition, that's unconstitutional. However, the problem is that the Supreme Court in our system ultimately determines what is or is not constitutional. And so even though it might appear to be unconstitutional on its face, the Supreme Court, through its own decisions, kind of defines the limits of its own power, which is really what makes the Supreme Court so enormously powerful when it chooses to be powerful. We should always keep in mind, though, that if the court gets out of bounds, if the court does things that the legislature, that Congress in this case particularly does not want to have done, they always have the power to do something about it. Congress can impeach and remove justices from the court. Congress can limit the court's appellate jurisdiction. Congress could do all sorts of things to trim the court's power if Congress chooses to do so.
Thank you, Dr. Smith. The Constitution gives the court the power to review the actions of the President and the Congress to determine whether they fit well with the guidelines of the United States Constitution. In other words, the Supreme Court is designed to make sure all government officials are playing fair. The only types of cases the courts do not oversee are impeachment cases of government officials. Those cases are seen by Congress. That is why it's so important to identify the power of the courts. Alexander Hamilton, one of our founding fathers and author of the Federalist Papers, said, "It can be of no weight to say that the courts, on the pretense of a repugnancy, may substitute their own pleasure to the constitutional intentions of the legislature." In other words, what Hamilton was saying was that the Constitution is the final law, not the opinion of the courts. The founders designed the entire government to work within the protective confines of the Constitution. Let's bring back Dr. Smith. Dr. Smith, how does Congress limit judicial jurisdiction?
There are a couple of ways that are very practical and a couple of them very impractical. Practically, Congress can always rewrite a law that the Supreme Court has interpreted in a way that Congress does not like. And so if the Supreme Court hands down a ruling and interpreting a congressional act and Congress finds that interpretation either unflattering or maybe even offensive to a majority of Congress, then Congress can simply rewrite the law. They can take care of that language if they choose to do so. Congress can also, just by simple majority, limit the court's appellate jurisdiction. What that means, most cases get to the United States Supreme Court by being appealed from lower courts, either state Supreme Courts or from lower federal courts. Congress can actually define what kinds of cases can go to the Supreme Court and what kinds of cases cannot through that appellate jurisdiction. And so let's say, for instance, that the Supreme Court is making a whole bunch of rulings on the issue of gay marriage. Let's say that eventually happens. And Congress does not like those rulings. Congress could then say, well, all issues of marriage shall stop at the Circuit Court of Appeals level, and the Supreme Court will not hear those particular cases. So those are very practical ways that Congress can act to limit the court's functions. In some ways, impractically, Congress can also impeach and remove members of the Supreme Court if they choose to do that. But as you can tell, historically, that's very difficult to do, and it's very unusual for the Congress to even talk about impeaching a member of the Supreme Court. They can also pass a constitutional amendment. We've seen that happen a couple of times where the court has made a ruling that Congress did not like, and so then Congress goes through the process of passing an amendment to the Constitution, which essentially makes the court's ruling null and void.
Thank you, Dr. Smith. Following the adoption of the Constitution in 1789, George Washington appointed the first Supreme Court judge, James Wilson. Today, the court consists of our Chief Justice and 8 Associate Justices. Supreme Court justices serve a life term on the bench, and more than 100 people have sat on the Supreme Court since its creation. Each year, around 10,000 requests for rulings reach the Supreme Court, but less than 150 are actually considered. Do you think you remember all that? Let's find out. Question 1. Which is not a responsibility of the judicial branch? A. To review cases and laws in light of the Constitution. B. To judge cases not solved by the lower courts. C. To judge cases not in state's jurisdiction. Or D. To try officials in cases of impeachment. The answer is D, to try officials in cases of impeachment. Impeachment cases are left to Congress to oversee. Question 2. True or false? The Supreme Court has the power to review the actions of the President and Congress in matters relating to the Constitution. The answer is true. Question 3. Who was the first Supreme Court Justice? A. George Washington. B. James Wilson. C. Thomas Jefferson. Or D. Alexander Hamilton. The correct answer is B, James Wilson, who was appointed to the Supreme Court in 1789 by President George Washington. Question 4. The Supreme Court consists of 1 Chief Justice and how many Associate Justices? A. 8, B. 6, C. 10, or D. Each elected president may decide. The answer is A. There are 8 Associate Justices, which are all appointed by the President and confirmed by the Senate. Question 5. Of all the branches of government, who has the least political power awarded them by the Constitution? A. The legislative branch. B. The executive branch. C. The judicial branch. Or D. They're all equal. The answer is C, the judicial branch, otherwise known as the Supreme Court, which has the least amount of power. How did you do? Hopefully we've taught you a little bit more about the judicial branch and the United States Constitution. I'm Alan Scholl for the Freedom Project. Welcome home.